fundamental aspect of the WTO is that it offers an innovative mechanism of settling trade-related disputes between the countries for the very first time in international trade history. The three main stages of the WTO dispute settlement process are: first, consultation between the parties; two, the adjudication by panels and, if applicable, by an appellate body; three, the implementation of the ruling, which includes the possibility of countermeasures in the event of failure by the lost parties. Mexico has been involved in several WTO dispute settlement cases as a complainant, as a respondent, and as a third party. When Mexico is a complainant, he is complaining about legal actions or proceedings from another country. When Mexico is a respondent, it's the other way around. Another country has accused Mexico of doing not right proceedings in some measures. And when he is a third party, he is being a mediator between disputes among other countries.
The first one is DS-446. It's from Mexico to Argentina, and it talks about measures affecting the importation of goods. This one was implemented in August 24th, 2012, and Mexico requested consultations with Argentina concerning certain measures imposed by Argentina on the importation of goods. So, the problem was because Argentina put a new document called Declaración Jurada Anticipada de Importación, DGAI, and a non-automatic license required for the importation of certain goods. But Argentina did not tell the other countries that these measures were being applied. So the country were missing with certain rules, with certain agreements, that these were GATT, chapters 3, 8, 10, and 11, the trade-related investment measures, the TRIMs, Article 2 and 6, import licensing art, Articles 1, 2, 3, 5, and agriculture, Article 4, safeguards, Article 11, and technical barriers to trade, Article 2.2. This dispute settlement hasn't been resolved. It does not have a resolution yet because Mexico withdrew its request for the establishment of a panel from the agenda of the GSP meeting on December 17, 2012, so it's still in consultation.
An example of a dispute settlement case where Mexico has been a complainant is the one against Costa Rica that was requested on March 8, 2017, just a year ago. Mexico requested consultations with Costa Rica with respect to certain measures that allegedly restrict or prohibit the importation of fresh avocados from Mexico to Costa Rica. Mexico claimed that the measures appear to be inconsistent with several articles from the Sanitary and Phytosanitary Agreement as well as with the GATT 1994 agreement. After the consultations between the parties, it is required the establishment of a panel, so the process may continue by offering a recommendation or resolution. Nevertheless, since this case is relatively new, there has not been established a panel yet, and no withdrawal or mutually agreed solution has been notified either. We're expecting that in the several next years, a panel could be established so it could emit a recommendation, and Mexico will be in the position to decide if he wants to implement it or not in its trade policy with Costa Rica.
The dispute settlement DS-451 is called China, Measures Relating to the Production and Exportation of Apparel and Textile Products, where the complaining party is Mexico and the respondent is China, with a resolution for consultation received on October 2012. In this case, Mexico claims that the Asian giant maintains a wide variety of measures that support producers and exporters of apparel and textile products, as well as suppliers in the cotton and chemical fibers industries. Along with the effects of the action taken by Beijing The Chinese goods are undertaking the Mexican goods on wealthier markets because of the quantity and the prices of the goods from China compared to the products of Mexico. The facts show that by the use of subsidiaries, there are specific changes in the market because of competitive advantages, quality of the products, as well as the quantity of the products. The governments implementing competitive advantages through subsidiaries have as an objective to have a boost on the exports. The fact is that this case has not been resolved and there is no panel yet. Dispute Settlement DS-331. This case is called Mexico Anti-Dumping Duties on Steel Pipes and Tubes from Guatemala, where the complaining party is Guatemala and the respondent party is Mexico, involving other parties called third parties, who are China, Honduras, Japan, the United States, and European communities. The case starts when Guatemala requests for a consultation on the WTO ground rules with Mexico because of the strictly based rules regarding anti-dumping against imports of steel pipes and tubes from Guatemala. Regarding the implementation of adopted reports, Mexico agreed with the panel report and intended to implement the ruling and recommendations emitted by the panel on 2007, having an estimate time frame of 6 months, and if possible, even less time. In 2008, Mexico informed that there was an elimination of the anti-dumping duties. Dispute Settlement DS-341. In this case, Mexico now plays a role as a respondent, while the European communities were the complainants. In order to understand better the following case, it is important to mention that on March 31st, 2006, the European communities requested consultations with Mexico concerning the imposition by Mexico of definitive countervailing measures on imports of olive oil from the European communities. In this context, and according to official information from the WTO webpage on dispute settlement cases, the European communities claims that the initiation and conduct of the investigation in this case, as well as the imposition of definitive countervailing measures, are inconsistent with Mexico's obligations. In addition to this conclusion made by the panel requested by the European communities, some recommendations were made to Mexico, which the country has implemented in order to bring the dispute measures into conformity with the WTO law. Dispute Settlement DS-526. This last dispute settlement is between Qatar and United Arab Emirates, and Mexico is considered as the third party. The name of this case is United Arab Emirates Measures Relating to Trade in Goods and Services and Trade-Related Aspects of Intellectual Property Rights. By August 10 of 2017, Qatar received a communication from the chairman of the dispute settlement body, covering a communication from the United Arab Emirates, stating that the United Arab Emirates would not engage in consultations with Qatar. As a result of the United Arab Emirates' refusal to engage in consultation with Qatar, the dispute has not been resolved.